So I want to talk about this lawsuit here, Newsom v. Trump. Newsom v. Trump. And a little, let's see, I got some notes, but let's take a listen to what Gavin Newsom actually has to say.
The Constitution sets forth limits. The President is a constitutional officer. The President of the United States works under the Constitution. And so we are very gratified by this decision. His section that he asserted the authority to overrule the objections of a state governor, clearly in the 36-page order, those cornerstones that he claimed or asserted were not met. Section 12-406, clearly there's no invasion, there's no rebellion. It's absurd. I want to make this clear. The National Guard will come back under my authority by noon tomorrow. The National Guard will be redeployed to what they were doing before Donald Trump commandeered them. The National Guard will go back to border security, working on counter-drug enforcement and fentanyl enforcement, which they were taken off by Donald Trump. The National Guard will go back to working on what we refer to as the rattlesnake teams, doing vegetation and forest management, which Donald Trump took them off in preparation for wildfire season. The National Guard, men and women, will go back to their day jobs, which include law enforcement, that he took them off the job. I will work with anyone to advance the interests of 40 million Americans that I happen to represent here in California. And so I've always maintained an open hand, not a closed fist. But I also am going to stand firm and tall and push back against lawlessness, against someone that does not believe in the rule of law, does not believe in constraints, does not believe in the Constitution, who is threatening judges, that threatens not to abide by orders, and Donald Trump better abide by these orders, or we have a constitutional crisis, likes of which we haven't seen in our lifetime. He must work under the constraints as a constitutional officer of the Constitution of the United States of America. That's what this court order demands of the President of the United States. He is not a monarch, he is not a king, and he should stop acting like one.
So, you heard the speech there. That's a little confusing because he was actually, he only won that case for like an hour or a couple hours, and the appeals court has reversed it. So I expect this to go to the Supreme Court. The California National Guard is vital in carrying out state functions such as emergency and disaster response, cybersecurity, and drug interdiction. For instance, 2,500 California National Guard members were activated in response to the destructive fires in L.A. In January 2025, some serve on Task Force Rattlesnake, the state's specialized fire combat unit. Others serve on the Counter-Drug Task Force, which specializes in stopping fentanyl trafficking at the U.S.-Mexico border. This was actually from the decision, the order granting plaintiff's application for temporary restraining order. This is case number 25 CV04870 CRB. So this is a civil suit. This is a civil suit. And so this was the order. Charles Breyer, the district court judge, had issued a 36-page order, and then this was the original complaint that was put in, and I want to read some of the quotes. So this is from Gavin Newsom's team, the Attorney General of California. Here it says, our people are governed by civil, not military rule. A government should be accountable to its people, guided by the rule of law and one of civil authority, not military rule. They point out 10 U.S.C. 12,406 says that those orders shall be issued through the governors of the states. 10 U.S.C. 12,406. Instead, Secretary Hegseth unlawfully bypassed the governor of California, issuing an order that by statute must go through him. The Posse Comitatus Act is on the side of California. It codifies these strict rules prohibiting the military from engaging in civil law enforcement unless explicitly authorized by law. They're also pointing to the jurisdiction of 28 U.S.C. 1331, 1346, 2201A, 28 U.S. 1391E. They also quoted the California Constitution, Article 5, Section 7. Let's see here. Here's another paragraph. While not unified in their views or tactics, many protesters seem to have gathered to express their opposition to the manner in which the Trump administration has executed its immigration agenda and to express solidarity with and concern for the individuals and families most directly impacted by the enforcement actions taking place in their community. So, whereas, some of the protests had happened earlier, Whereas some of the protests were happening earlier. There were like 250 to begin with, but then after the ICE force and Trump and National Guard and the Marines, then it became like thousands of protesters were out on the streets. So in a large way, the counter-protest, it escalated things. The more National Guard that they poured into the streets, the more the protest went. So, they said that they handled it. They were able to handle it and everything was okay. They even quoted one of his tweets in the thing. Here's the actual law. Section 12,406 has 3 reasons that the president can federalize the National Guard. Whenever the United States or any of the commonwealths or possessions is invaded or is in danger of invasion by a foreign nation. So, is this an invasion? Not a lawful invasion, not a legal invasion, not like the government is invading the country. Some people might say immigration is a kind of invasion, but it's not like, Bolivia or Mozambique. It's not like China has invaded. It's not like North Korea has attacked our country. So there's no invasion. Like you heard Gavin Newsom says, it's absurd. There's no rebellion, too. Number 2 says if there's a rebellion or danger of a rebellion against the authority of the government of the United States, then he can federalize the National Guard. And then the president is unable with irregular forces to execute the laws of the United States. Now that one could actually fit in there, but then it says here, the president may call into federal service members and units of the National Guard of any state in such numbers as he considers necessary to repel the invasion, suppress the rebellion, or execute those laws. Orders for these purposes shall be issued through the governors of the states or, in the case of the District of Columbia, through the commanding general of the National Guard of the District of Columbia. So that's actually really important. Just pay attention to what it says. It says, orders for these purposes shall be issued through the governors of the states. Through the governors of the states. Not that they're subordinate. It's not like one is over the other. But it's just saying that the president can, mobilize. But then it says that the orders goes through the governor. And so you got to get the governor on board. You have to be friendly. You can't just treat them as if they're, your damn slave or some sort of, as if they're not a damn governor. This is the only second time in our nation's history that a president has relied on the exclusive authority of this provision to federalize the National Guard. The first was President Richard Nixon when he called upon the National Guard to deliver the mail during the 1970 Postal Service strike. This is also the first time since 1965 when President Johnson sent troops to Alabama to protect civil rights demonstrators under a different federal authority that a president has activated a state's National Guard without a request from the state's governor. So that is, remarkable. Basically, the president is sitting there stealing the state's National Guard, which, during crises you're allowed to. There's exceptions to the rule when you're allowed to do that, but you're supposed to go through the proper channels. And according to this 36 opinion by Charles Breyer, he did not go through the proper channel. Let's just carry on. Let's see, is there any more else that I quoted? Here's another thing. They talk about Task Force Rattlesnake. You heard Gavin Newsom talk about that. The state's specialized fire combat unit. The service members have specialized training in wildland fire mitigation and prevention and direct fire suppression, and would be highly difficult for the state to replace. The 79th Infantry Brigade also contains counter-drug task force members that specialize in providing support to stop the trafficking of fentanyl at the U.S.-Mexico border, because these National Guard members have been federalized for 60 days unlawfully. As detailed below, the state of California is deprived of resources to protect itself and its citizens and of critical responders in the event of a state emergency. Claims of first calls of action ultra vires, all defendants. That's Latin. That's Latin, which means something or another. Let's see here. What else do we got? What else do we have? Violation of the Posse Comitatus Act is imminent, if not already underway. The Posse Comitatus is on the states' rights, so this is interesting. Now it's, it's not the Republicans, I guess in the way, well, whatever. It seems like things have reversed since the Civil War. The Civil War, the Posse Comitatus were the southern states, and the southern states are talking about states' rights, and now it's the western states, right? I guess Democrat states, maybe blue states you could say. The blue states are talking about states' rights, and the blue states are talking about the Posse Comitatus. So interesting how history comes full circle. It doesn't always repeat itself, but it rhymes. But then sometimes it just flat out just repeats itself. So, there's that. Let's see here. Cato had mentioned something about Cato mentioned several things, but to live by one man's will become the cause of all men's misery. He said that, but he also mentioned the militia in some sentence here. He just had one little sentence about the militia. But it was interesting. He was saying that, the president could be a tyrant and that he could take the militia from one state to march into other states at the opposite side of the continent. So you got to watch out for that. He actually begins this little Anti-Federalist number 5. In my last number, I endeavored to prove that the language of the article relative to the establishment of the executive of this new government was vague and inexplicit, that the great powers of the president connected with his duration in office would lead to oppression and ruin, that he would be governed by favorites and flatterers, or that a dangerous council would be collected from the great officers of the state, that the 10 miles square, if the remarks of one of the wisest men drawn from the experience of mankind may be credited, would be the asylum of the base, idle, various, greedy, and ambitious, and that the court would possess a language and manners different from yours. Vice President as unnecessary as he is dangerous in his influence, that the President cannot represent you because he is not of your own immediate choice, that if you adopt this government you will incline to an arbitrary and odious aristocracy or monarchy, that the President possessed of the power given him by this frame of government differs but very immaterially from the establishment of monarchy in Great Britain, and I warned you to beware of this fallacious resemblance that is held out to you by the advocates of this new system between it and your state governments. So, there you go. There you go. The great Cato, the anti-federalist Cato. Trenchard and Gordon. I don't know. What am I saying here? Let's see here. Here is the appeal. So we got a little bit of the appeal right here. Actually, we got the whole appeal. It's 31 pages. 31 pages. You're just supposed to have a short, little, plain little sentence. What the hell? Don't they know how to write? They need to go to the Pro Se Clinic. These people need to go to the Pro Se Clinic. I've talked to most of the things, so